Welcome everyone to the Federal Bar Association Key Tam Sections, The Rounds, FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy False Claims Act decisions and developments. I'm Scott Oswald, Programming Chair of the Key Tam Section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
Let's start with an alleged visa fraud case that is also wrapped in the False Claims Act. It's a type of case that we've discussed in the past where an employer is accused of shortchanging the government by bringing in workers on a cheaper visa that is actually required by law. The case is U.S. ex rel. Kini versus Tata Consultancy Services. Comes to us from the D.C. Circuit. And the panel joins what seems to be, Tejinder, an emerging view that this sort of claim isn't actionable under the FCA, even if the government is losing money by a knowing deception. Does the outcome make sense to you?
Yes and no. So the question in this case is whether the evasion of paying for the more expensive H-1B visa by applying for cheaper visas that are not the appropriate one to get is the evasion or reduction of an obligation under the meaning of the Reverse False Claims Act provision. And what the court holds is it says, look, you have no obligation to pay for an H-1B visa unless you apply for an H-1B visa. So had you applied for the visa and somehow not paid, that might be actionable, but you applied for a different visa, and so you had no obligation to pay the money for the H-1B visa. And I think that is slicing the salami a little thin in the sense that if you knew you had to get an H-1B visa, and the way you decided to evade that obligation was just by knowingly applying for the wrong one, like why would that be any better than if you applied for the right one but paid too little or something? It's a strange case to me. You could think of other analogies, like, for example, import duties. If you misrepresented where what a particular type of good was, characterized as one thing when you knew it was the other, I don't think we'd normally say, well, oh, you only have an obligation to pay the duty on the goods you declare. It doesn't seem like, in other words, it doesn't seem like one lie should be able to insulate an underpayment. But that does seem to be the emerging view among the circuits.
So what would it take for a different circuit maybe to reach a different conclusion, creating a circuit split?
Well, they'd only have to agree with the logic that I gave. I think the Trump administration has been quite vocal about its desire to stop visa fraud, to make the border stronger, and to protect American jobs. And so you could imagine situations in which the Department of Justice is a little bit more excited about some of these cases. This was a case where the government did not intervene. I know, Scott, you had a case, your firm previously, where the government was a little bit more excited and it settled before it got out from under seal, I believe. So I think there's a possibility that some of those cases may come up in the future in circuits that don't have controlling precedent. We may even see a circuit split that leads to a Supreme Court decision. But I think government interest is going to be the variable that might drive change here.
Next up is an FCA retaliation case from the Seventh Circuit, Lewis versus AbbVie Inc. Here we have a relator who says he faced punishment after objecting to some aggressive off-label marketing of a drug, which is, of course, a common basis of FCA lawsuits and indeed some big settlements. Here the panel says that the employee's objections weren't specific enough to trigger the protections of the False Claims Act. Tejinder, how could that be? Surely AbbVie must know that improper off-label schemes can violate the FCA. What do you say?
Yeah, so this is a case where the whistleblowing reported alleged regulatory violations, FDCA violations potentially, but didn't explicitly call out the possibility of False Claims Act liability. And so the court said, well, you didn't really put the employer on notice that there was potential FCA exposure here and that you were engaged in protected activity under the FCA. Again, I think it's a thin cut. It's saying that something that a sophisticated drug company surely knows could lead to FCA liability, has led to FCA liability in the past, doesn't count unless it's more specific. But that is how the court decided to, the lens they decided to use to look at the allegations.
So any lessons here for relator side lawyers?
Yeah, I think first, for relators and their lawyers, if they're advising them while they're still employed, you might want to make sure that the warnings are sufficiently explicit and that that's documented somewhere. Second, I think if there are other statutes that might apply that have retaliation claims, for example, SOX or an employment statute, you may want to consider adding those claims as well if you have a retaliation claim, just to make sure that you're insulated against the weight of this ruling.
Let's turn to US XREL Sam Jones Company, LLC versus Biotronik from the Ninth Circuit. This is a public disclosure case. I know you love those, Tejinder. How did this one turn out?
This one turned out just fine. So the relators won here. I think that this is an interesting case in that it grapples with a question that courts have been wrestling with for a while, which is at what level of generality do you compare public disclosures to the relator's complaint? And again, it's one of these judgment calls, kind of like what we've been talking about up until now, where the court kind of has to decide, is this close enough or not close enough to trigger the public disclosure bar. And what the Ninth Circuit does here is it says, even though there were New York Times articles that reported on the ways that this medical device manufacturer was compensating physicians and possibly engaging in kickbacks, they didn't talk about the specific scheme at issue here, which was that the company was hiring a physician's brother to market the devices. And so it was a three-way payment scheme. That wasn't called out in the press articles or in the other public disclosures with enough granularity, the Ninth Circuit held, to reveal the specific fraud alleged in the case. And so the district court's order throwing out the case on public disclosure grounds was reversed, and the case went forward. Interestingly, I think this is a case that possibly you could have thought of as going off under the original source exception. That is to say, the articles maybe disclosed a lot of what was going on generally, but the relator's disclosure materially added and was independent of those things. The relators in this case, Sam Jones Company, was a proxy for two former employees of the company. So they were like insiders in the classic sense, who you ordinarily wouldn't think the public disclosure bar applied to. And I think that fact may have had something to do with why the court rules in their favor.
Let's turn to the DC Circuit for what is mostly a 9B case, US XREL Winnon versus Lozano. The DC Circuit, Tejinder, isn't known for setting a high bar for 9B pleading, but here we have a split panel where the majority says that the relator has alleged fraud via the anti-kickback statute only faintly with squinted eyes, while a partial dissent says that the indicia of fraud for one claim are in plain view. Has the DC Circuit moved the goalposts?
I don't think so. The Rule 9b question that ordinarily comes up is just, have you done enough to allege that there's a false claim after you allege a bunch of underlying misconduct in detail? That's really not what's at issue here. In this case, what's at issue is, are there reliable indicia of the underlying fraud itself? And again, the standard calls for judgment calls. And so as you look at what the majority and the dissent are doing, they're just kind of like squinting through the same lens and coming to very different conclusions. In this case, the kickback violations, there were several kinds, but the one that caused the disagreement between the majority and the dissent is that the defendant had these marketing gifts that it was giving out. And it was a fair question to ask, and I think the majority even asked it, what are these gifts for if not to induce referrals of patients, i.e. to be kickbacks? But then they said, there are actually no agreements clearly tying compensation to referrals. And so we're going to say that you didn't have enough to plead the AKS violation. The dissenting opinion by Judge Katsas says, well, look, it's a pretty logical inference when you have these massive amounts of marketing gifts that they're being given for a reason, and that reason is to induce referrals. At the pleading stage, that's surely got to be enough. And so, no, I don't think that the legal standard has really moved. But I do think that this is an illustration that the legal standard in Rule 9b cases, and really in all of the types of cases we've discussed today, is quite malleable. There's a lot of room for courts and judges to reach individually divergent conclusions based on the same set of facts. I'll add one last kind of interesting thing here, which is the split between the majority and the dissent in this case is not what you would ordinarily predict if you were just doing sort of law student level calculations about who's going to vote for who. The two judges in the majority are both Democrat appointees, generally regarded as fairly liberal, and therefore generally more pro-plaintiff. And the dissenting opinion in favor of the relator here is from a conservative Trump appointee, generally probably regarded as more pro-defendant. So this also goes to show that even when you have these malleable standards, that doesn't just mean that pre-existing ideology wins out. It can be a little more unpredictable.
Let's now turn to the 11th Circuit U.S. XREL Sedona Partners versus Able Moving and Storage, Inc. The question here was whether a relator may move forward with discovery while a motion to dismiss is pending, and whether material from such discovery can be used to amend the complaint in order to meet the 9B standard. In this case, the trial court said no, but the appellate panel says yes. Tejinder, you like this decision.
I do. So for a long time, you've seen judges say that Rule 9b acts as sort of a gatekeeper to discovery. Unless you clear the Rule 9b bar, you cannot do any discovery in a case. And therefore, it would also be improper to use material from discovery in meeting Rule 9b's requirements of particularity. But there's nothing about that in the rule. No such phrasing appears in the rules, the commentary, anything else. Judges kind of made it up and or borrowed it perhaps from unrelated laws like the PSLRA in the securities context. And so that logic here is refuted by the 11th Circuit on straightforward textualist grounds. They just say, look, the rule doesn't say that, doesn't say where you have to get the information from. It just says you have to plead with particularity. If you got the information from discovery, that's fine. I think it is correct under the text of the rule. And it's nice to see a court plant a flag on the other side.
Finally, Tejinder, in the 11th Circuit, arguments have been scheduled for the Zafirov case. This is the potential blockbuster case on constitutionality of the qui tam provisions of the False Claims Act. You're going to be arguing the case for the relator. Tell us about the timetable for Zafirov, and also maybe a couple other similar cases that are percolating other circuits, maybe the 3rd and the 6th.
Yeah, in Zafirov, the court has told the parties that the case will be placed on the argument calendar for the week of December 8th. We don't yet know what day. We don't yet know who the panel will be. That information will be available about a month before the actual argument date. And of course, it's possible it could move, but as of now, that's what everybody is expecting for the argument date. There are two other cases. There's a pending appeal in this Janssen case from the 3rd Circuit. This is an appeal from a jury verdict and judgment where constitutionality is one of several issues that have been raised. Constitutionality is an open question in the 3rd Circuit, so that will work itself out, but probably won't move as quickly as Zafirov. In the 6th Circuit, there was a judge in the district court who certified this question for interlocutory appeal. A petition for leave to appeal has been filed. 6th Circuit has not yet accepted it as of the day we're recording this, so we don't know if there's going to be an appeal there yet. But the 6th Circuit does have on-point precedent saying that the FCA is constitutional, which makes me think the petition is likely to be denied, or at least the result of the appeal would be a foregone conclusion unless the court hears the case en banc in the first instance.
A very busy season ahead for the False Claims Act for sure. Tejinder, thank you. And thanks to each of you for joining us for this episode of the Federal Bar Association qui tam sections, The Rounds, FCA News with Tejinder Singh. We'll see you next time.